It goes to show it's not something coming out of the blue, etc. And with regard to Dr. Scorti-Bello, it was remarkable on the redirect that I've never seen a prosecution essentially go after the opinions and conclusion of their own medical examiner when they basically said, the medical examiner, I can't call this a homicide. The manner of death is undetermined. And the medical examiner says, I don't see any motor vehicle impact injuries. There couldn't be anything more apt, more probative than whether or not the injuries to the decedent are from a motor vehicle. The Dr. Welcher himself is saying they are. That's the essence of his opinion. It's the essence of his test. We get to be able to, respectfully, Your Honor, say, well, wait a minute. You said you looked at the autopsy. You said this. You highlight it. But you're going against the medical examiner on whether there's motor vehicle injuries. The experts can't, Your Honor, cherry pick and choose from documents. They can't use it as a shield and a sword. They can't put up, for example, Dr. Scorti-Bello's autopsy report, cherry pick things that benefit from them, and then and they did it on direct. And then all of a sudden on cross, when we want to go and test that, they say, oh, no, you can't do it. Your Honor, this whole argument is absurd. And it's antithetical to the Sixth Amendment. And even if, and this is my last point, even if this were merely a civil case, this would be routine cross-examination against the expert on the side. So in conclusion, Your Honor, I respectfully request that Ms. Reed and her team be allowed to exercise their constitutional right to cross-examination. The keystone of a defense in a criminal trial is absurd, and it's antithetical to the Sixth Amendment. And even if, and this is my last point, even if this were merely a civil case, this would be routine cross-examination against the expert on the side. So in conclusion, Your Honor, I respectfully request that Ms. Reed and her team be allowed to exercise their constitutional right to cross-examination, the keystone of a defense in a criminal trial, cross-examination, and that they be able to take the shield that the prosecution is trying to put on us and be able to combat the sword that the prosecution has put forward with regard to trying to cherry pick from this information, and that we get to proceed, and we get to proceed undaunted from all the serial objections yesterday that interrupted my cross-examination. Thank you, Your Honor.
What arises from the litany of complaints by the defense is that there is no constitutional right to usurp the rules of evidence. There is no case law, as much as they urge the court and yell out the word case law and constitutional right and Sixth Amendment right, there is no case law to support what they are trying to do. It is a simple endeavor that is clouded by all the rhetoric that they offer. And it is clear, and the court knows what they're trying to do. They're trying to pit the inadmissible opinion of a non-testifying witness against a testifying witness. They have asked Dr. Scorti-Bello what her opinion is, and although it's not consistent with our reading of the case law, they were allowed to introduce that it was an undetermined cause of death or mechanism. That evidence is already in front of the jury, but they can't simply repeat it because it sounds good to them or they think it's helpful. Simply because a witness uses a document or looks at it or uses part of an autopsy does not let them regurgitate an opinion that's already in evidence to try to phantom cross-examine an expert. Dr. Welcher is clear. He did not rely on Dr. Scorti-Bello's conclusion that this cause of death is undetermined. In fact, as an aside, he said, I wouldn't, because she's not qualified for that. And so this is a simple game. Let's pit one witness against the other and suggest that Commonwealth's witnesses are inconsistent. They take it a step further. They want to relive what they think is their past success last year, in this case, without actually calling the witness. They want the jury to hear their perspective that a past witness had confusion in his analysis, but they don't want to call the witness. They want you to allow them to do that, not just shouting it out and have sustained objections, which has happened this entire case, but they actually want you to be able to allow them to ask Dr. Welcher these questions, which he did not rely on. We had a voir dire. He was clear. He did not rely on the analysis of Trooper Paul. He did not rely on that determination or undetermined determination by Dr. Scorti-Bello. It is that simple. They try to throw some fluff out and they throw around some documents. We have slide 22. Simply because there's a suggestion that Trooper Paul might be the hand in the picture is not an anchor, it's not a tether, it's not an adoption, it's no such thing. In fact, if you look at that photograph, it was taken by Zach Clark. So by the rationale of the defense, they should now be able to ask Dr. Welcher any question they want about Zach Clark's opinions, efforts, what Zach Clark did. It is a photograph that he considered, not an opinion, not an analysis. It has nothing whatsoever to do with Dr. Welcher's analysis or opinions. In fact, the evidence is to the contrary. He came out, conducted an independent analysis, did all of the work himself, considered documents, and he was specific about what was part of his opinion and what was not. And this information was not part of his opinion. They turned to the Google map. Bit misleading. This was generated by Google. Two separate people used the same program, but when you look at the CARS report and you look at Dr. Welcher's PowerPoint, it's different. Dr. Welcher's has a map on the side, and when you look at the numbers themselves, the CAR report says minimum 36.1, maximum 38.8. Dr. Welcher's slide, 37.9, 38.1. So in no way did he adopt anchor, tether, use as any basis. In fact, his is different and separate, as all of his analysis is. And so the portrayal of this necessity of information so they can sneak in inadmissible opinions with no witness is simply improper. There is no case law. There is no legal support for it. They cannot reach back into last year and manipulate a witness and ask him about something that he didn't rely on because it feels good or it sounds good for their case. Dr. Welcher did not rely on Trooper Paul's analysis or reports, and he did not rely on the conclusion of Dr. Scotty Bell of undetermined. If they want to call Trooper Paul, well, maybe they can try to do that, but Dr. Welcher is not the right witness for it. These opinions, to try to do a credibility value, is a core preclusion in criminal law, a core preclusion. You cannot vouch for the credibility of another witness. You cannot comment. It's like asking, did the police officer lie when he said the light was red? It's the absolute same analysis. It just has a lot of icing on it.
Very briefly, bring the jury. Start getting the jury ready, please.
Your Honor, with regard to Trooper Paul, Mr. Brennan did not address 80% of the slides that I addressed that showed the basis. When he talked about the picture, making it seem like the picture is the only thing we're relying upon, there's clearly other items. But even the picture, Your Honor, the purpose of the picture is it's got the odometer reading. That's why they took the picture, and that's the tether. So the photo is completely relevant. It's not who's in it. It's the fact that that's the odometer reading they're using. Next point with regard to case law. Mr. Brennan presents none to go against the common sense law that has been there for years. The other thing, Your Honor, is with regard to Mr. Brennan keeps trying to put my arguments into a credibility, like we're trying to attack the credibility of Trooper Paul. He says that we're trying to redo last trial. To the contrary, Your Honor, it's the Commonwealth that brought Trooper Paul into the second trial through Dr. Welcher and Dr. Welcher's reliance on all the work of Trooper Paul. They've brought it in here, and because of that, we get the right to cross-examine it. Last point. This is not about credibility. He keeps saying something that's not happening, that we're going to attack the credibility of Trooper Paul. What we want to do is to say to Dr. Welcher, you have brought up Trooper Paul. You have used his odometer reading. That odometer reading tethers through to Google. It tethers through everything you're doing. It's the foundation. But what you're ignoring, Dr. Welcher, are all the key cycle results that come from that odometer reading that you relied upon. Dr. Welcher himself can't cherry pick, grab things that he needs from Trooper Paul to do his analysis, and then the Commonwealth say, but you can't go after that because it somehow has Trooper Paul's name on it. It's illogical, Your Honor, and it's incorrect under the law. Thank you.
So I disagree with you, Mr. Lessie. I'm not allowing in the line of questioning regarding Trooper Paul, and I'm not allowing the line of questioning regarding Dr. Scotty Bello. So that's my ruling. Let's bring the jury in. Well, come over here because they're on their way.
I did this at very low speeds, and you'll see, and we'll throw this from two different angles. That's me showing I'm doing test 2. This is from a camera that we have pointing down at it. This is the speed. You'll see it's only about a 2-mile-an-hour impact. But even a 2-mile-an-hour impact redirects me back and causes me to rotate and take a step.
Yes.
This is the post-contact image of the transfers onto my arm. Actually, the yellow paint, you can see from my hand is here. This is from the arm and forearm. Here's the paint transfer pattern. What I've done is I've taken these yellow lines to show the extension of the components on the rear of the exemplar Lexus. Then I've done this extension of those same components on the rear of Miss Reed's Lexus and shown how the approximate location of the fractures in the taillight match up with the approximate location of the contact of the arm onto the taillight. Slide. We've now overlaid the Lexus laser scans on top of the image of the Lexus. So there's the video image, still image that we took from the video. And here's where we overlay the laser scan of the Lexus. So we've overlaid the laser scan of the Lexus onto the Lexus. We've overlaid the laser scan of the Chevrolet onto the Chevrolet. And we've overlaid the laser scan of the scene onto the scene. So now what that allows us to do, we now know the position of everything in there. And we've also tracked the position of the tire tracks. We lined it up in the video, we lined it up in the scene, we have the two vehicles. We can get the exact position of the vehicles when that Lexus stopped. So when that Lexus stopped, that's going to be the maximum engagement. So from that information, we can get the angle of the vehicle, we can get the degree of overlap, the impact configuration, and I had the opportunity to inspect Mr. O'Keefe's vehicle. There's no damage where these marks are. So, sure, it knocked the snow off, but it wasn't sufficient to cause damage to his vehicle. I said, and watch. Shoulders come in, then the head contacts the ground. What you see is if you fall backwards and land on a very hard surface or hard surface, you'll get extremely high loads on the head.
Mr. Brennan?
Commonwealth moves to introduce and play clip 26.
So, I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. Did he come and hit the back of my car and I hit him in the knee and he's drunk and passed out and asphyxiated or something? And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over? Or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability.
Exhibit 207.
Your Honor, the Commonwealth rests.
Okay. Does counsel want to see me?
We do, Your Honor.
Okay. So should we send the jury out or should...
Probably, yes.
So, jurors, so everybody can sit. So, jurors, the Commonwealth rests. That means that the Commonwealth's case has been presented to you for your consideration. So, I need to meet with the lawyers for a few minutes, so we're going to send you back out. I can tell you that it now appears that we're at least on schedule, if not a little ahead of schedule. So, we'll send you back out for a short recess.
Rise to the jurors.
Right. Can counsel come to sidebar, please?